Serial 28, I was to argue but I'm seeking time.
28 अगर पहुँच नहीं
ये मॉडल 41 में है, उसमें ज़्यादा मतलब I could not find much merit in there. Therefore, I'm not saying.
So I can post it to you.
I'm not saying therefore in camera. Therefore, from this side, I'll only play one next week. Whatever your lordship may impose cost if your lordship so, then also because it is my fault that he had entrusted me the file. The learned council
इसको कोई cost है?
serial 28
आपके ऊपर cost करते हैं?
वो जो भी हो अल्लाह
Sir,
वो जो भी रूल है उसके लिए हम
ऐसा रूल हमने नहीं बनाया.
हाँ
तो it's not.
But my only prayer would be that because I'll be requesting the another council to argue, I'll not. I could not find anything, therefore I. Now I can come here. In 28, your lordship, I request. After 3 days, on Monday, whatever, Thursday, that's it.
28, serial number 20. At the request of the council for that night, close this case on Thursday
Thursday.
at 2:15.
Yes.
Serial number 40, Lordship.
4:17.
Last revision, let's say after hearing sometime else, Lordship has observed that the sister needs to be made a party nurse because 1/3 partition nurse. We have filed an interlocutory application for including her as a party, so it shouldn't come in the hearing for hearing. It is coming for hearing.
Mediation notice.
Well, it's important.
Serial 14 to AP number 132 of 2023. With IA number 12835 of 2025. Council for the Appeal has submitted that this petition has been filed for adding the
Sister of the appellant.
sister of the appellant,
Appellant and respondent.
sister of the parties. As party in the proceedings, she submits that a share has been allotted to her in the partition suit, although she was not a party in the suit. Notice कर देते हैं इनको?
Yes, sir.
Let the notice be issued to MS Geeta Devi, wife of Shashi Bhushan Rajwar, resident of Jogiji, PO Jogiji, PS Chandan Kyari, District Bokaro. The proposed party to be added, for which requisites be filed by the applicant within a period of 1 week under ordinary process and speakers. The notice should accompany a copy of the memo copy along with the included document. Post this case on 15th October, office to tax papers.
I may mention from the legislation, D9 legislation. The matter was listed in the final disclosure. The legislation same nature of facts that were involved in the second appeal of 72 of 2025, which was admitted with order dated 10/9/25. Leadership on that day, there was a direction that if this matter is not taken up today, we may mention it. And this particular second appeal is listed on 7th of 2, and both the cases will be taken.
What's the serial number?
Serial number 9.
9
Second appeal 129 of 2020.
129.
Of 2020.
There is a petition for ignoring the defect.
No, Your Lordship, all the defects have been ignored. It is an admitted appeal. The
Then why
respondents have
5261 is showing as pending? इसका file pending? Has already been indicated essay number 129 of 2022. Learned Council for the Appeal has submitted that as per the office note, defect number 7 has already been removed. And RA number 5261 of 23 was filed seeking to ignore defect number 7.
Yes.
He submits that the same petition has become infructuous. Considering the submissions, IA number 5261 of 23 is closed. The learned council, essay number 129 of 2022, the learned council for the appellant has submitted that on similar points, another second appeal,
Yes.
being essay number
72 of 2025.
72 of 2025 has already been admitted by this court by claiming substantial question of law, and the same is scheduled to be listed on
7th of October.
7th of October. It means that this case be also listed on the same day. Parties same है कि अलग है?
No, it's different part.
Let this case be listed on 7th of October. एक साथ सुनवाई नहीं हो पाएगी.
Yes.
Parties are
Parties are different.
अब दोनों में से आप कौन सा केस पहले करेंगे यू डिसाइड, क्योंकि एक केस नहीं होगा फिर ऐसे नहीं चलेगा ना. You
Yes.
have to tell us which case you want to do first. So which one have you chosen to do first?
Your Lordship, I'll seek instruction and
Auto case item 28, second appeal 446 of 2007.
ये कौन सा
Item 35. Item 35, second appeal 7 of 2008.
case? Why did you mention this case?
Lords, the essay has become infructuous. Prior to that, I'll be just mentioning, Lords, there was an eviction suit which was filed in 1994, Lords. Eviction suit number 52/1994. And subsequently, that was allowed in favor of the respondents. There against the appellant preferred a revision before this honorable court, which was rejected. And subsequently, the respondents filed their execution case number 11/2001 before the court below. Thereafter, a miss case was being filed by the appellants on the ground that they have already provided the possession to the respondents. The same was rejected. And subsequently thereafter, my lords, title suit 125 of 2006 was filed by the appellant on the ground that one of the co-sharer of the respondent has made an agreement to
So
sell.
where do I get all this?
My lords, this is there on the record, my lords. That is there on record. That title suit, they again filed a miss case for seeking a stay on the eviction. And against that appeal, and now this second
Stay
appeal,
on eviction.
eviction, and that was rejected. They preferred appeal. That was also rejected, and that appellate order was impugned before this honorable court by way of second appeal. Meanwhile, my lords, when during the pendency of this second appeal, the title suit before the trial court has already been decided in favor of the respondent.
There was an interim order. after
Yes,
the
my lord, that was an interim order, and that interim.
आज तुम कोई 12 बजे इन्फॉर्मेशन दिए मेंशन करने के बाद
वो जो डिस्पोजल हुआ है
जी बोला हम सप्लीमेंट्री हम फाइल कर दिए हैं
उसके अगेंस्ट में हम फर्स्ट अपील फाइल किए हैं सॉरी सिविल अपील नंबर 62 ऑफ 2025 बिफोर द लर्नेड डिस्ट्रिक्ट जज इसी डिस्ट्रिक्ट पेंडिंग.
ठीक है,
दैट इज डिफरेंट.
वो तो अपनी जगह है.
हाँ ठीक है.
तो इंटेलेक्चुअल स्टेटस का तो ऑर्डर खत्म हो गया ना.
नहीं हम इसमें आर्गुमेंट करेंगे क्योंकि आज हम पढ़े भी नहीं है ना हमको इन्फॉर्मेशन नहीं दी है.
पढ़ लीजिए आप, कल के लिए रख
नहीं कल के लिए नहीं, कल तो हमारा एक केस ऑलरेडी हुजूर रखे हुए हैं.
इसमें
इसको फ्राइडे को रख दिया जाए, हम इसको असिस्ट करेंगे फ्राइडे. हम भाग नहीं रहे हैं, फ्राइडे को रख दीजिए इसको। हम तो हर केस उम्मीद करते हैं, हम तो भागते ही नहीं हैं, हम तो हर केस करते हैं। हमारी एक्चुअली खबर भी कल भी करते हैं तो पढ़ के आ जाते हैं, 12 बजे खबर की है।
It was at serial 35. I expected that he must be having the file. That is the reason I mentioned it.
You rarely come to this court. Serial number 35 का फाइल लोग लेके नहीं आते.
That I understand, but that I understand. But the thing is that this is the reason I mentioned.
So you should have some
That I
assistance.
understand.
ठीक है. देखिए. Essay number 7 of 2008. The learned counsel for the respondent has submitted that one supplementary affidavit has been filed indicating that the present secretary has become infructuous. Counsel for the petitioner submits that the matter be posted on Friday. Post on Friday as first case at 10:30. इसका एक सीक्वेंस आप बना के दे देंगे, थर्सडे तक दे देंगे हम.
ओके।
Permission item 24, first appeal 240 of 2024.
This is to be formally agreed.
Wait.
FA number 240 of 2024. Counsel for the applicant is present. NCR. The learned counsel for the applicant has submitted that the records have already been received from the concerned court. However, the case has not been formally admitted. It is also submitted that otherwise the case is ready for admission. Reduce the record, consider the submissions. Admit. Notice diagram. The respondent number 1 has already appeared by filing a filing. Therefore, no notice will be issued to respondent number 1. So far as respondent number 2 is concerned, he will be the deputy commissioner. कोई स्टेट का काउंसिल है यहाँ पर? स्टेट नोबडी. नो नोटिस नीड बी. इनको नोटिस कर दीजिए. Let the notice be issued to respondent number 2 for which requisites under ordinary process. Speed post से हो जाए. Requisites under speed post be filed within a week. Office to tax speed post to them. Post on 1st of December.
For hearing under order 41 row 11 item 25 second appeal 191 of 2013.
So joint compromise.
Yes.
You have other respondent?
For respondent 3 and 4.
What about other respondent?
But one respondent also signed.
One.
Just informed you.
Indirectly. One. Advocate.
Yes, look at the parties.
One.
Parties.
Joint compromise कैसे है? How have you settled with this?
Not the petition, not the appellant, not here in order. Petitioner plaintiff was not filed. The respondent number 1, 3 and 4 number. They are all brothers. and not on the basis of a family settlement not, and one compromise which has happened between the family they have issued a cheat. On the basis of that not he has filed a declaration of title and right. And thereafter first in the first court, trial court 4 issues have been declared in my favor and the 4 issues have been declared in other parties' favor. They have filed an appeal against that order. I have also filed an appeal against that order. Now, if the appeal has been dismissed, which I have filed, and the appeal has been allowed in their favor. And that I have filed this. But the appellant number 1, so the sole appellant is the brother of respondent number 3 and 4. In the IM.
Just a moment. It is read that to accept the application filed on behalf of the appellant and the respondent number 2 to 4.
Yes. One is not, he has already sold his portion of land to the respondent number 2.
Okay, so he has nothing to say.
Yes. And 2 he has already made affidavit before this week. I have also made that affidavit. Page 11 of the IA application.
सबका एक्टिविटी
Yes. Page number.
तो वेयर इज ही रिस्पॉन्ड नंबर 2 कहाँ है भाई एफिडेविट इसमें रिस्पॉन्ड नंबर 4 का है रिस्पॉन्ड नंबर 3 का है रिस्पॉन्ड नंबर 2 का है एंड अपीलेंट वेयर इज ही कहाँ है गुलाबी नहीं है आप तो रहिएगा तभी होगा आपका भी रहना चाहिए इसके पास होगा ये दो अलग अलग केस में दोनों में जॉइंट कॉम्प्रोमाइज फाइल किया
Get that lot of common order था अभी.
तो दोनों केस लिस्टेड है
हाँ दोनों केस की 25
में दोनों में फाइल किया जॉइंट
दोनों
कॉम्प्रोमाइज
में एक ही lot of common बदल ये आइए फाइल के थे बहुत
तो हम लोग
ये लेटर on the registry has told me that you have to file one of these 25 इसलिए हम उसको ऊपर
आईए में दोनों मेंशन है पेज 1 और 2
दोनों केस मेंशन है
हाँ दोनों केस मेंशन है सेकंड
Item 27, second appeal 223 of 2013.
ऐसे number 223 of 2013. Nobody acquiesced on behalf of the applicant. The case was adjourned on repeated occasions.
Serial number 27 was playing for Mr. Vestivali, and it's a person is not on the board, so it's not
He did not argue the case. Did he argue the case? Are you sure? If you are asking time in his name, then he should come and argue the case. Nobody else should. Be sure of it.
It is there in our list.
Sorry?
Serial number 27,
Yes.
and such all.
His cases are generally not being argued by him. So don't ask time in his name. In general, I'm telling you. His cases are being argued by his junior. Isn't it? If you are asking time on the basis of,
Only 1 week.
I will give you time.
Then
Then it should not happen that on the next day somebody else will come. That is not proper, no? So you will come. Essay number 223 of 2013. The learned counsel for the applicant has submitted that this case has to be argued by Mr. Mahesh Tiwari. He had come to the court and went back home.
Yes, due to some personal
The
reasons.
learned counsel submits that Mr. Mahesh Tiwari had come to the court, but on account of some personal reasons, urgent personal reasons, he has left the court. He submits that the matter be posted on
Next week.
Tuesday next. Post this case on the next Tuesday to be taken up at 2:15 as the first case. Check. उनके सारे सेकेंड अपील्स और सिविल मैटर्स उनके जूनियर बहस करते हैं, बोल बहस करते हैं. So I will look for him on next week. Got it? Got it?
Item 29, second appeal 452 of 2017.
Is supplement? But then.
Was it plaintiff appellant concurrent pending? Suit file what है? Permanent royalty declaration of permanent royalty right title in mutation and also confirmation of position.
So,
And also ये सूट है ट्राइबल सूट है.
tribal suit what is tribal suit?
ट्राइबल सूट आदिवासी जमीन उससे रिलेटेड सूट है. इसमें डीसी है नेसेसरी पार्टी है. रेस्पोंडेंट नंबर 12 ये डब्ल्यूएस फाइल किए हैं प्रॉपर इंक्वायरी के बाद अपना एविडेंस वगैरह लगाते हुए. इनका डब्ल्यूएस को ना अपीलेट कोर्ट द्वारा और ना ही ट्रायल कोर्ट द्वारा कंसिडर नहीं किया. सेक्शन 46 सबसेक्शन 3A ऑफ सीएमडी
वो
है
respondent number कितने थे?
और बाद में ये पार्टी ऐड हुए हैं. रिस्पोंडेंट नंबर 12
Deputy Commissioner Jharkhand.
डिप्टी कमिश्नर.
उन्होंने अपना WS फाइल
डब्ल्यूएस फाइल
एविडेंस नहीं दिया.
हाँ प्रॉपर इंक्वायरी के बाद हम पर
एविडेंस दिया कि नहीं दिया?
हाँ एविडेंस
उनका बताइए कौन सा एविडेंस? कौन सा एविडेंस है जो कंसिडर नहीं है? Which evidence?
पेज 16 और से देखा जाए लास्ट पेज अपीलेट कोर्ट है. As against this, the defendant number 12 has stated in WS that Lanes under मौजा नंबर 302 देवघरा खाता नंबर 20 प्लॉट नंबर 2369 area 0.38 acre is recorded in the record of right under Adivasi Ranger Khata and the name of Barku Besra. Barku Besra is my ancestor and others are there. It appears from the Jamabandi register 2. The same is entered in the name of Pran Besra. Pran Besra one of the recorded tenant और ये मेरे पक्ष में रेलिंग्वेज किए थे अपना इंटरेस्ट. Then said land is under occupation of the family member of Pran Besra. It is further stated that during inquiry it could not be established that the fact about partition of the property is sharer has sold any portion to another, as no such document has been produced before the revenue officer. It is also found that Patan Besra, Pawan Besra, dependent number 9 and 10, is our brother lordship and grandson of Manjula Besra. After partition of occupying the said land under plot number 2369 area 0.19 acre. It has further been stated that during inquiry it could not be ascertained whether
You see, he filed a written statement.
written
The point is, इनका गवाह कौन? Who has he proved this particular document, the inquiry, has it been exhibited? You tell us, where is the exhibit? W has exhibit होता है क्या? The inquiry report, has it been exhibited?
the inquiry report.
तो फिर उनकी तरफ से कोई गवाही देने नहीं आया, WS फाइल करके सो गए. तो क्या होगा उससे? इंक्वायरी रिपोर्ट अगर एग्जिबिट नहीं हुआ तो क्या होगा? That has not been exhibited. Mere statement in WS is a gospel truth. Deputy Commissioner कुछ बोल देंगे तो it is full and final. Yes.
इसमें सेकंड क्वेश्चन है ये कंफर्मेशन ऑफ पोजीशन के लिए फाइल हुआ था और इसमें ये मटेरियल इशू था, ये इशू फ्रेम ही नहीं किया गया. इसमें ट्रायल कोर्ट का देखा जाए पेज 30 में इशू फ्रेम हुआ. पेज 30 सूट है कंफर्मेशन ऑफ पोजीशन के लिए इशू ही फ्रेम.
एशिया केस हुआ था आपके अगेंस्ट में?
नहीं इसका टाइटल सूट होता है. एग्जीबिट वन लॉटशिप के मालगुजारी रसीद है, ये भी कंसिडर में किया. एग्जीबिट 2 सर्वे का बयान है जिसमें ज्वाइंट पोजीशन दिखाया जा रहा है. एग्जीबिट 3 रिविजनल सर्वे का बयान है, इसमें रिमार्क्स फॉलोइंग ज्वाइंट. एग्जीबिट 4 सेटलमेंट कंटिन्यूस साथ में
Issue number 7. Finding on issue number 7.
विवादक बिंदु संख्या 7 का निस्तारण। उक्त विवादक बिंदु संख्या 7 इस आशय का है कि क्या वादी और औपचारिक प्रतिवादी संख्या 10, 11 को वाद भूमि पर रैयती अधिकार प्राप्त है। विवादक बिंदु संख्या 4 और 5 के निस्तारण के दौरान प्राप्त निष्कर्ष से स्पष्ट है कि वादी अपने इस अभिवचन को साबित करने में सफल नहीं हुआ है कि वादी खाता संख्या 20 का अंकनाधारी रैयतों के बीच भूमि के आपसी विभाजन में विवादित भूमि करण बेसरा और बड़कू बेसरा एवं उनके भाइयों को आवंटित थी। ये एग्जिबिट A1, 2, 3, 4 ये दिखा रहा है और डीसी का इंक्वायरी रिपोर्ट में भी रजिस्टर 2 का जिक्र किए हैं। इसमें है कि करण बेसरा के नाम से माल दी रसीद 2007 तक का है। उस एविडेंस को कंसीडर नहीं किया गया है और उसके बाद करण बेसरा विवादित भूमि में अपना अंश बड़कू बेसरा एवं उनके भाइयों के पक्ष में त्याग दिया। लेकिन यदि यह मान लिया जाए कि खाता संख्या 20 के अंकनाधारी रैयतों
You are claiming the property on the basis of a sale deed?
No,
on the basis of recorded rayat. You are the descendant of recorded rayat.
descendant.
Who is the recorded rayat? And how are you related to the recorded rayat?
There are 5 recorded rayats of it. Page 18 also है, paragraph 8. Appellate होता है। It appears from the pleading of the parties that there is no dispute between the parties that the suit land along with other land were originally belonged to Barku Besra, Manu Besra, Paika Besra, son of Bhutan Besra, and Karan Besra, son of Raghu Vans Besra, and Sahib Besra. Plaintiff का केस लॉजिक कि 23 मतलब प्लॉट नंबर है, उसका टोटल एरिया 38 डेसिमल। मेरा कहना है कि सर्वे खतियान बनने से पहले इस जमीन का बंटवारा हो गया था और 19 डिसमिल जमीन मिला था प्राण बेसरा, बरकू बेसरा। प्राण बेसरा के फादर बरकू बेसरा को अलॉट हुआ था और 19 डिसमिल जमीन साहेब बेसरा को पश्चिम की तरफ अलॉट हुआ। वो भी पार्टीशन मान रहे हैं, लेकिन उनका कहना है कि 38 डिसमिल पूरा जमीन जो है साहेब बेसरा को was effected in the year 1930 and according to partition Sahib Besra board 19 decimal of land in plot number 369 on the western side. In the eastern side Barku Besra and his brother Karan Besra was allotted 19 decimal of land, out of which Karan Besra relinquished his interest in the plot in favor of Barku Besra and his brother, and thus Barku Besra bought the half of the plot within the area of 38 decimal. इसी में 19 डिसमिल जमीन जो है इसके लिए हम राइट टाइटल इंटरेस्ट के लिए पेश करेंगे। पार्टीशन के बाद जो लैंड प्राण बेसरा को मिला वो हमको रेलिंक्विश किए, उसी 19 डिसमिल जमीन के लिए हम सूट लाए राइट टाइटल। We admitted a
You have
lot.
yourself stated that the property was transferred in favor of Devu Murmu, but that deed was not under challenge.
नहीं वो तो हम तो उसके लिए अभी सूट ही नहीं लाए हैं।
सूट तो नहीं लाए हैं, लेकिन एग्जीक्यूशन तो हो गया था ना डीड का।
वो अलग जमीन है, उससे हमको कोई मतलब नहीं है। आप इसका प्लेट का रिलीफ पोर्शन एक बार देख लीजिए। हमारा प्लेट का रिलीफ पोर्शन शेड्यूल, इसमें लैंड विद इन मौजा नंबर सच एंड सच ऑन द ईस्टर्न साइड 19 डेसिमल विद बाउंड्री वॉल, और ईस्टर्न साइड का 19 डेसिमल जमीन के लिए। और ये जो बिक्री हुआ है ये वेस्टर्न साइड का जमीन बिक्री हुआ है।
You were the plaintiff, right? You claimed that there was a partition in there 1930.
Yes.
Correct? Did you prove it? Did you prove the partition? Because your entire claim is lying on the basis of partition of the year 1930.
Yes.
Did you prove the partition? What is the finding on the point of partition?
पार्टीशन कुछ नहीं है फाइंडिंग, वो केवल रिमार्क्स कॉलम में सबका शेयर जो है जो अलग अलग हो गया है उसी के आधार पर कर दिया पार्टीशन मान लिया। जबकि एग्जिबिट 1 2 3 4 ये जॉइंट पोजीशन दिखा रहा है, सबका आंसर दिखा रहा है इसमें।
Joint possession exhibit 1 2 3 4
हां
is the record of rights, correct?
यस। पार्टीशन के लिए न डिपेंडेंट के द्वारा कोई वैसा डॉक्यूमेंट लाया गया है तो पार्टीशन हुआ है, न प्लेंटिफ के द्वारा।
What is the basis on which you are claiming 19 decimal of land? On what basis?
खतियान
Khatiyan. You see, after partition, if any portion is relinquished in favor of anybody, that has to be there by way of a registered deed. Partition खतियान में लिखने से क्या होगा?
वो तो हमारा खतियान
There is no title deed to that effect. In Khatiyan it might have been mentioned. So, where is the deed?
हम तो सूटी लाएंगे और उसको on the basis of खतियान।
No, but you are claiming. No, your entire claim is based on the basis of Khatiyan.
Yes sir, हम
Right.
सूटी लाएंगे खतियान के basis पे।
Okay.
मेरा जो इतना क्लियर है कि हम खतियानी रैयत थे, तो ये एडमिटेड है कि हमारा एंसेस्टर जो है और रिकॉर्डेड टेनेंट है और उसके हम डिसेंडेंट हैं।
Yes, so.
तो बस यही तो हम
नहीं, that's not your case. आप पढ़िए.
हाँ,
Para
ये
number 2, appellate court का judgment.
The plaintiff case as made out in the pleading of the plaintiff in short is that land which Mauja Devgara previous Bagmara Mauja number 302 खाता number 20 plot number 2369 area 30 decimal along with other land were originally belonged to and in possession of Barku Besra, my ancestor also, Manjul Besra, Paita Besra, son of late Bhutan Besra, Karan Besra, son of Prabhuvansh Besra and Sahil Besra, and was recorded as such in their name in the last settlement record of right. It is further stated that Barku Besra and others while in possession during the lifetime immediately after publication of record of right partitioned their properties including the suit plot. It is further stated that every partition was held in the year 1930 and according to the partition Sahib Besra bought 19 decimals of land in plot number 2369 on the western side and eastern half of the land was allotted to Barku Besra and his brother and to Karan Besra. Karan Besra relinquished his interest in the plot in favor of Barku Besra and his brothers, and thus Barku Besra and his brothers both absolute half of the total area of 38 decimal.
So ये relinquished है. This has to be by virtue of a registered deed.
No,
What is the area? What is the area of the suit property?
19 decimal. 19 decimal.
But you claim to be the owner of the entire, got the absolute half of the 38 decimal, that is 19 decimal. And this 19 decimal you are claiming on the basis of this relinquishment deed.
Yes.
And this relinquishment deed is not a registered document.
वो तो deed नहीं.
Deed नहीं है तो फिर कहाँ से आपका कोई केस बनेगा? नहीं बनेगा ना?
लेकिन बाकी एग्जिबिट एक बार देख लिया.
ये क्या exhibit है?
इसमें इन लोगों का गवाही भी है. ये प्राण बेसरा
गवाही से टैकली नहीं हो सकता है ऐसे।
उसका डीसी का इसमें डब्ल्यूएस भी है के बाद में.
इससे क्या होगा? डीसी की तरफ से कोई गवाही नहीं आया है, आपका रिपोर्ट
वो कम से कम कंसीडर करना चाहिए.
एग्जिबिट नहीं हुआ है।
एग्जिबिट नहीं हुआ लेकिन उनका डब्ल्यूएस का जिक्र तो होना चाहिए ना. एक लाइन
जिक्र है, उतना ही जिक्र है।
नहीं, जिक्र ही नहीं है. अगर जिक्र होगा तो हम
नहीं, उतना ही जिक्र है कि फाइल किए थे।
हाँ है.
जैसे प्लेट का हर चीज प्रूव करना होता है ना, डब्ल्यूएस का भी हर चीज प्रूव करना होता है, ऐसे तो नहीं होता। And you're contesting them. Defend number 1 to 4 were the contesting defendant, right? और आप किस साइड का प्रॉपर्टी क्लेम कर रहे हैं? वेस्टर्न साइड,
ईस्टर्न.
you are the descendant of Sahib Besra.
वो ने मंजूर है.
And Manjul Besra and Barku Besra were brothers.
मंजूर है.
They were brothers.
जूनियर देख.
Yes, they were brothers.
बारको बेसरा मंजूर बेसरा ब्रदर.
Brother.
रेयर कंफर्मेशन पोजीशन के लिए हम उसका इशू ही फ्रेम नहीं है क्योंकि
नहीं,
मटेरियल इशू है. इस इशू से ही डिपेंड कर रहा है.
you were seeking confirmation of possession.
इशू एटलीस्ट फ्रेम है.
You were claiming permanent rayati, right?
And also confirmation possession.
No, it is not.
And this is how that you also be plating possession of them. the commissioner is the guardian of the tribal supremacy, and as such, the defendant number 12's written statement ought to have been considered, but the said ignorance is immediately linked out of the order portion of the interim judgment in decree. Both tripod as well as lay.
Okay, essay number 452 of 2017. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against a judgment dated 2/8/2017 with the bracket decree signed on 22/8/2017 bracket close. Passed by the District Judge Roman 12 Ahmedabad, entitled appeal number 51 of 2013. Whereby the appeal has been dismissed. The trial court judgment has been passed the trial court judgment is dated 30/3/2013. Decree signed on 12/4/2013. Passed by the Civil Judge, Junior Division number 2, bracket close Ahmedabad, entitled suit number 128 of 2002. The learned counsel for the appellant has submitted that the Deputy Commissioner, Ahmedabad, being a necessary party in the case, was made a defendant in the proceedings, as the suit belongs to scheduled tribe category. Suit property belongs to scheduled tribe category. He has submitted that a written statement was filed by defendant number 12, which is apparent from the interim judgment passed by the learned first appellate court, but the report submitted by the Deputy Commissioner has not been taken into consideration. He has further submitted that the suit was filed for a decree for declaring plaintiffs and pro forma decree number 10 and 11 apostrophe S permanent priority right over the scheduled land on confirmation of their possession. He submits that no issue with regard to possession was framed. The learned counsel submits that in view of the aforesaid facts and circumstances, a substantial question of law been framed, and the second appeal be decided. He has also submitted that that substantial question of law arises for consideration in spite of concurrent findings recorded by both the courts. Okay? However, during the course of argument, it is not in dispute that on behalf of defendant number 12, no witness was examined, and the statement made in the written statement by defendant number 12 was not proved by any witness on behalf of defendant number 12. After hearing the counsel for the appellant, this court finds that the specific case of the plaintiff was that the suit property total area 38 decimal, along with other areas where, along with other land where originally belonging to and was in possession of Varku Besra, Manjulu Besra, Paika Besra, son of late Bhutan Beshra and Karan Beshra, son of Raghuvansh Beshra and Sahili Beshra. And further case was that Bhattu Beshra and others by the possession were in possession immediately after the publication of record of rights. Partitioned their property, including the suit cost. It was further stated that family partition was held in the year 1930, and according to partition, Sahib Beshra got 19 dismil of land in plot number 2369 on the western side, and eastern half of the land was allotted to Bhattu Beshra and his brother and to Karan Beshra. It was further case of the plaintiff that Karan Beshra relinquished his interest in the plot in favor of Bhattu Beshra and his brothers, and thus Bhattu Beshra and his brothers got absolute half of the total area of 38 dismil, that is 19 dismil on the eastern side of the plot. Karan Beshra got other land in lieu of his share in plot number 2369. In possession of 19 dismil of land on the eastern side was allotted to Majlu Beshra by Bhattu Manjul and Kaika, partitioned their properties amongst themselves in the year 1932. It was the further case that Manjul died leaving behind his only son Maheshwar Beshra, who continued to be in possession of 19 dismil of land, and Maheshwar died leaving behind his three sons, that is the plaintiff and defendant, namely Pattal and Pawan Beshra, who were in joint possession of their posted land. It was further case of the plaintiff that 19 dismil of land on the western side was also agreed to be sold by Banerjee Beshra. Sold by Banerjee Beshra, and he has received consideration amount from the plaintiff and put him in possession thereof and constructed the boundary wall. It was further case that the attitude of Banerjee Beshra for non-compliance of the terms of the agreement of sale, the plaintiff filed a suit for specific performance of contract against Banerjee Beshra, being title suit number 81 of 2001. The plaintiff came to know that defendant number 2, Sanju Devi, for disturbing the plaintiff and his brother, had executed a collusive deed in the name of defendant number 1, who is stranger and resident of another village. The sale deed in question, that is deed number 987 dated 2/3/2001, was executed by defendant number 2 in favor of defendant number 1, which according to the plaintiff was void and collusive and without consideration. It was the further case that defendant number 1 had not acquired any title by virtue of the aforesaid sale deed dated 2/3/2001, executed by defendant number 2, Sanju Devi, and it was also stated that the sale deed was hit by the provision of section 46 of Tobacco Tenancy Act. The sanction for sale was also fraudulently obtained, and the cause of action for the suit arose on 2/3/2001 at Dhanbad PS and District Dhanbad. This sale deed was not specifically challenged.
No.
Uh,
ये तो ऐसे नलायक भारत था दूसरे इसलिए चला
the sale deed dated 2/3/2001 was not specifically challenged in the suit. So far as the defendants are concerned, defendant number 1 to 4 filed a written statement stating that the suit was misconceived and was filed with an ulterior motive to grab the land purchased by the answering defendants on payment of full and final consideration money. It was further stated that before last cadastral survey settlement, there was amicable partition amongst the recorded buyer and they were in peaceful possession of their respective shares. And thereafter, in the remarks column of C.S. Khatyan, they had no concern with each other. The plot number 2369 measuring area of 38 decibel was in exclusive possession of Sahib Besra, and the other recorded buyer had no right, title, interest and possession in any manner with respect to plot number 2369. The defendant submitted that according to the partition of the year 1930, Sahib Besra got 19 decibel of land in plot number 2369 on the western side, and eastern half of the plot was allotted to Barku Besra and his brother and to Karan Besra. Where such statements were all false, baseless, the defendants narrated the real facts and also asserted that the plot number 2369 measuring an area of 38 decibel was in exclusive possession of Sahib Besra and other recorded buyers had no right, title, interest or possession with respect to the same plot. So far as defendant number 12 is concerned, as recorded in the improved judgment, appears to have filed a written statement stating that the same was recorded in the name of Barku Besra, son of Bhutan Besra and other dayas. And during inquiry, it could not be established. The fact about partition could not be established, as no documents were produced before the revenue officer. It was also found that Patan Besra, Pavan Besra, grandsons of Manju Besra after partition were in occupation of plot number 2369 area 0.19 acres. And it could not be ascertained whether Bamali Besra, क्या नाम है? ये पढ़ा नहीं रहा. Yes, ये last word क्या है page number 4 में? Last word नीचे. Page number 4. Banerjee Mishra whether Banerjee Mishra and Sajano Devi had executed any agreement of sale of land to others as agreement deed was not produced. And it was admitted position that the partition of share between the years of late Bakru Mishra was done long ago. And due to disputes between the parties, the present suit was filed. However, no witness was examined on behalf of defendant number 12, and the inquiry report, if any, was consequently not exhibited before the court concerned. The learned trial court framed the following issues for consideration. Paragraph 4 of the appellate court judgments in Hindi. Trial court का judgment is in Hindi.
जी.
The learned trial court, after considering the materials on record, ultimately dismissed the suit. And so far as the learned first appellate court is concerned, the point for determination has been mentioned in paragraph 7, wherein the learned court has recorded that the main question in the appeal was whether the plaintiff/appellant had got permanent royalty right over Mauza Devdhara, Mauza number 302, Khata number 20, plot number 2369, which was the schedule of the plaint, and it was also to be decided whether the plaintiff/appellant was entitled to get the relief of confirmation of possession as paid for or not. The learned appellate court also considered the materials on record and held that and decided the appeal against the appellant. The learned court also observed that the plaintiff had sought relief of declaration of his royalty right and of pro forma defendant number 10 and 11 in the suit property and confirmation of possession, whereas he had already made an averment that a sale deed was executed by Sanu Devi in favor of Devu Murmu, but in spite of that he had not sought any declaration over the said sale deed. The learned court thereafter was of the view that the learned trial court had rightly dismissed the suit. Having gone through the improved judgments, this court is of the considered view that there is no substantial question of law involved, and accordingly this appeal is hereby dismissed.
Chapter 30, second page 484 of 2017.
Made cases. Apprenticeship in 1920, CNT Act was amended and a provision was incorporated in section 87 as clause EE in subsection 1, giving power upon the revenue court to decide a title. Here the first court, faced with an application under section 87(1), asked an order that he has no power to decide critical title, and missed to even notice the provision of law which says that he may, in a given case, relegate the matter to the civil court for deciding. And when it went to the appellate court, first appellate court also said the same thing, endorsing that view that revenue court has got no jurisdiction to decide that. It means they missed their statutory jurisdiction. That's one aspect. Second is that in addition with respect to our title, there was a parallel judicial proceeding going on before the subject in a land acquisition case. So all the materials, evidences to prove my title were exhibited in that proceeding. It took some time to obtain certified copies from that court. And we filed an application before the original court for giving us leave to produce them. That leave was granted. We produced them, but without noticing them, the court has passed the order. Naturally, the court said that I am not going into the issue of title at all. And then in the first appellate court, we filed an application under Order 41 Rule 27, bringing those materials.
What
And
happened
one
in
more. Just two more sentences, I say, to introduce this. In the first appellate court, Order 41 Rule 27 application was filed, bringing all those materials which were filed for the trial. Plus, in the meanwhile, in that land acquisition case, in which all these materials were exhibited, judgment had come, achieving the time. So that judgment also was filed. The first appellate court did not even consider the 41A, 41 Rule 27 application. Now, in addition, what has happened, we have filed the second appeal now. During the second appeal, that land acquisition case's judgment has been upheld in first appeal against in that land acquisition proceeding. So that judgment also we have brought before your ladyship by way of an application under Order 41 Rule 27. So these are the three aspects. Now may I please from the records whatever I have argued. All the substantial questions of law will automatically fall into place. Your ladyship will come to the first judgment. Or your ladyship will see the CNT Act for a moment. Section 87, subsection 1, clause E. The first judgment you will may I please?
This raises that provision that the court may refer.
Section 87.
CAT Act.
Section 87 has got two subsections. Subsection 1 is about the original proceeding. Subsection 2 is about the appeal. That's the first appeal. Subsection 1 provides for certain clauses. May I read the full section?
No, we are aware of that. There
Yes.
is that you have to refer the matter.
Provides. What? Provides.
Yes.
The revenue officer may, subject to such rules as may be made in this section also, transfer any particular case or class of cases to a completed civil court.
Where is 264?
264 is the rule making power.
Rule.
That's simply the enabling provision.
Has any rule framed?
In addition, Rule 74, sorry, the rules, CIT rules 1959 are there. I was examining it. Fortunately, there was no indexing to this. But rule would in any case make only the procedure.
When you filed your application under section 87,
Yes.
the matter was pending in the land acquisition case.
Yes. Now that entire thing is culminated into an appellate judgment which is before your ladyship by way of an IA under Order 41 Rule 27 filed here. Taking note of the
There is
entire.
a proviso also, provided also that, you read that. Was proviso to, second proviso to section 87.
Also that in any suit under this section, the revenue officer shall not try any issue which has been or is already directly and substantially an issue between the same parties or between parties under the rule. they or any of them claim in proceeding for settlement of rent under this chapter where such issue has been tried and decided, or is already being tried by Revenue Court under section 86. So it was not tried and decided back then. It was pending. So section something 18 to section 11 CPC is provided here, not something 18 to section 10 CPC. So res sub judice principle is not incorporated.
What is the finding of the learned tribunal? Just come to the finding with respect to jurisdiction.
May I request your ladyship to come?
Any issue framed?
Yes, yes. It's just a 4-page judgment.
Where is the issue?
Starts from page 22. And kindly come to the next page, page 23. मुख्य विचारणीय बिंदु निम्न है. मुख्य विचारणीय बिंदु निम्न है. क्या विवादी जमीन पर वादी का हक बनता है अथवा प्रतिवादी का? विवादी जमीन पर दखल किसका है? क्या हाल घाटा में परिवर्तन करना न्यायोचित है?
Then there is no specific
give me
issue
1
on the
minute,
point
your
of
ladyship, please.
jurisdiction.
Pardon.
There is no specific issue on the point of jurisdiction of the court.
No, not at all.
Where is the finding?
The page thereafter, next page. The last page, 4th page, page 25. 6th line from bottom. विवादी जमीन में क्रिटिकल टाइटल की बात है, अतः इस न्यायालय के कार्य क्षेत्र से बाहर की विषय वस्तु है. I could not lay my hands.
I couldn't get that portion.
Your ladyship, the last page. Your ladyship, you find वाद अस्वीकृत. Last line. वाद अस्वीकृत. Skip 3 sentences. विवादी जमीन में क्रिटिकल टाइटल की बात है. Ladyship. 6 lines from bottom. अतः इस न्यायालय के कार्य क्षेत्र से बाहर की विषय वस्तु. These are the 2 sentences which depicts failure to exercise jurisdiction. And a sentence before that is the other matter. I filed the evidences, he says not filed. That also needs to be depicted from the order sheets. This Honorable Court was pleased to grant me opportunity to place the order sheets by way of supplementary affidavit which I have done. Including the appellate, the first appellate court also.
What happened before the first appellate?
Yes. Your ladyship, the first appellate court's judgment starts from page 26. First 3 pages are cost item. Your ladyship may skip. Ladyship, may just take 1 more minute. The issue was one Bhikkhu Mahato's 6 or 7 sons we are all claiming from. Now the rival party is saying in different proceeding, different stand. In one proceeding, she is also saying that we have derived title from our common sister Bhikkhu Mahato. In the other, she says my father obtained it from a third party, Rani. And in yet another proceeding, they say that my grandfather obtained it, whose father was Bhikkhu. Always trying to set up different sources of title. The judgment, your ladyship, may for the time being skip the other portions and come to that portion where the court says Revenue Court has no jurisdiction to decide title, page 44, internal page 19, running page 44. That's the last page. 1, 2, 3, 4, 5, 6, 7, 8, 9, 9. The Revenue Court has no jurisdiction to decide title. Completely in teeth of clause EE, which was brought way back in 1920 by amendment.
Why?
Stated.
Formal. And your ladyship will find in this whole judgment, elaborately written, there is not a word whispered about our Order 41 Rule 11 petition.
Okay, for the learned counsel for the appellant, the learned counsel for the state is present. This appeal has been heard under section 87 and bracket 2. read with section 224 of the Nagpur Tenancy Act. The learned counsel for the appellant has submitted that as per the provision of section 87 of the Nagpur Tenancy Act, the authority has got the jurisdiction to decide any question relating to title in land or to any interest in land as between the parties to the suit. He has submitted that as per the first proviso to section 87 within bracket 1, if the revenue officer, the revenue officer may, subject to such rules as may be made in this behalf under section 264, transfer any particular case or class of cases to competent civil court for trial.
Addition one thing, addition please addition one thing which I proposed, I want to have that skipped from my side. This was not a case where critical title was involved because case in which title has already been decided. In this case, title had actually been decided in 1950. Deciding on a decided title is not critical.
No, that is too much because there are so much of documents which we will see that. The learned counsel has submitted that. Please hold on. The learned counsel has submitted that the suit under section 87 was decided by observing that, was dismissed by observing that the suit property including suit property involved critical title and the same was beyond the jurisdiction of the learned trial court. And the appellate court also observed that the revenue court had no jurisdiction to decide the title. It is submitted that it is submitted that if the title was found to be critical, then the matter ought to have been referred to the civil court for trial in terms of first proviso to section 87. However, at the same time, the learned counsel for the appellant has submitted that no complicated question of title was involved in the case, and therefore therefore the suit was required to be decided on merits. The learned counsel has further submitted that certain documents were filed before the learned trial court, before the authority, trial court the new one, before the revenue officer, but the same was not taken into consideration, and accordingly an application under Order 41 Rule 11 CPC was filed before the learned first appellate court. But the first appellate court did not pass any order on the state application, and ultimately the appeal was also dismissed.
Saying that revenue court has no power.
Saying that revenue court has
no jurisdiction
to decide the title. Having heard the learned counsel for the appellant, this appeal is admitted for final hearing on following a substantial question of law. whether the first appellate court has committed illegality by observing that while discussing the appeal, by observing that the revenue court has no jurisdiction to decide the title. And thereby ignoring the provision of section 87 within bracket 1 within bracket EE of the Diplomatic Tenancy Act. D. The trial court, having observed that the dispute involved question of critical title, instead of, it ought to have referred the matter to a competent civil court for trial, instead of discussing the suit filed under section 87 of the Diplomatic Tenancy Act. Whether the learned court whether the improved judgment is to be set aside on account of non-consideration of the petition seeking additional evidence filed under Order 41 Rule 27 of CPC. That should be sufficient.
To note an elevation. The first question elevation will say both the courts. The first question, when they ignored, the first court has ignored clause E, both the courts. Second court also said the revenue court has no jurisdiction. So that could be added. Both the courts again. And there are
Did you notice to the respondent number? Yes.
The materials were not only filed with the first appellate court, filed in the trial court also. Trial court says it has not been filed.
I've already observed. We do not know. Let the records come. And even if it was not filed at the trial court, you can always file at the first
No,
appellate
that's
court.
their relation, but I have filed it and I have brought it.
I've already
The evidence I have brought by supplementary affidavit.
We will not see that evidence. We will see the records.
So that additional, we only observe that leave to frame further questions.
How does that make a difference? I just do not know. First appellate court is a continuation of the trial court, and if it is already filed there, and the first appellate court has not taken into consideration the additional evidence, the matter has to be remanded, nothing else. Simple. The first appellate court will see the additional evidence. They are bound to pass an order on that. Yes
Just
or
let
no?
me express this relation.
No, that's
What the first court did, original court makes a wrong statement that I have not filed it before the court.
We'll see that. If you notice to the respondent number, how many respondents are there? 2 to 47.
Numerous. Out of them, 41 to 47 are
2 to 47,
pro
for which refuses under speed post and ordinary process be filed within a period of 15 days from today. Call for the records from the concerned court. वहाँ तो आ गया होगा record. Concerned court and also from the concerned revenue officer who has passed the order under section 87.
Original and first appellate court.
Date 2nd of December.
DT of right.
Masud.
Masuk is item 25 with 26.
Yes, are you there?
The matter has been complied between the parties.
And so far as respondent number 1 is concerned, you have got nothing to say. You are for respondent number 1?
3 and 4. Yes.
3 and 4.
Respondent number 1 is not appearing.
Not a thing,
From where do we get it that he has already sold the property?
that what I have also mentioned, Lord, in the judgment also it has been mentioned.
Where is it in the judgment?
I have also Lord mentioned in para 7 of the IA application.
I used to know one judgment में दिखा. Respondent number 1 was contesting.
No,
Did he file written statement?
he has filed written
Where is
statement
that?
along with respondent material. Yes, ma'am. Lord, in page 36, Lord.
36.
Yes, ma'am. Last 5 and it has been mentioned there. First side from the defendant number 1 by virtue of a registered sale date number 6139 dated 20/10/2005.
From defendant number 1 by virtue of registered suit. It was sold to whom?
Lord, respondent number 2, Lord. That's one, sir. He is the contesting respondent and he is. Page 53 of the judgment, Lord. Trial court has Lord gives conclusion with respect to Lord this judgment, this sale deed. Page 53.
Page 39 में भी है.
Yes.
Bottom में, it is also stated in the written statement that defendant number 1 constructed the house over the schedule A with roof and gave boundary upon the shed, and thereafter he sold the same to defendant number 2 on payment of funds.
Lord, it was a Lord written statement has been filed. Lord, the conclusion part would kindly have Lord page 51.
51. Yes.
Lord, page 53, Lord, the last 25, para 25. In these circumstances, I come to this conclusion with some material motive and just create problem. Defendant number 1 has excluded sale date in favor of defendant number 2. With respect to 1/3 share in the schedule A and on the basis of materials available on record, it can safely be inferred that defendant number 2 has got no possession of the purchase and certainly there appears to be a sham transaction between defendant number 1 and defendant number 2. And sale date excluded by defendant number 1 in favor of defendant number 2 never been acted upon. Accordingly, this issue decided in favor of the plaintiff.
the title remained with defendant number 1.
But he has already sold that property.
Maybe if there is a declaration that this is sham transaction, the title remain with whom? Right? If the sale deed of defendant number 1 in favor of defendant number 2 is a sham transaction, then the title would remain with whom?
But that the first trial court also not that given a judgment that the appellant or the plaintiff is the
बिना उसको उनको नोटिस किया है जॉइंट कॉम्प्रोमाइज अलाउ नहीं कर सकते।
नहीं वो ट्रांसफर कर दे तो वो नेवर दे हैव क्लेम देयर आफ्टर।
हम लोग देखिए हम लोग जॉइंट कॉम्प्रोमाइज ही उनको नोटिस में भेजेंगे।
हाँ वो he has come also on that day। वो तीन अलग-अलग बच्चे भी थे वो आए हुए थे उसमें से।
वो आके अगर एफिडेविट कर देंगे that he has got no objection to this joint compromise, the matter will end. Because if the sale deed executed by defendant number 1 is found to be a sham transaction, then title remains with defendant number 1. Title कहाँ पास हुआ? Defendant number 2.
ये contesting respondent, the contesting the second person, he has filed the appeal also against the judgment of this lord. That has also got lord that particular appeal has been upheld lord in favor of respondent number 2. The appellate order है.
Oh, कहाँ है वो? Where is that order?
But lord I have next question.
Your parents with your आएंगे?
नहीं किसी second appeal में.
कहाँ लगा है?
Number 44.
Defendant number 2 must have come up in appeal.
नहीं defendant number वो respondent number 1 ही आया. appeal में भी वो आया है defendant number 2 also.
So where is that judgment?
Page 56. The appellate court order.
Page 56. इसमें क्या हुआ?
ये सारा इनके फेवर में ही respondent के फेवर में ही the appeal has been dismissed which I have filed and the appeal has been allowed with the other factors.
सेल डीड के बारे में क्या पाएंगे आप लेट को? नंबर 14 हाँ बताइए क्या पाएंगे?
Trial court has come to the conclusion that the suit property is joint property. If the same is the joint property, certainly the defendant number 1 would get 1/5 share in this property. It is held by the trial court that the defendant was not entitled to net 1/3 part of this scheduled property. I am not in agreement with the finding of the trial court. The trial court has considered the suit property as joint property and made a nominal partition. Held that the defendant number 1 can net 1/5 property share of the property. I have arrived at the decision on the previous issue and found that the DC has purchased the suit land in the name of his 3 sons out of his own fund. If the property is purchased by performance number 3, saying from his own fund, it is self-acquired property, but the Benami Transaction Act comes into play. Thereafter, it has been discussed. Says in case of Benami transactions, the owner can be considered as the real owner of the property. The exhibit is the original deed of the sale, the exhibit of the sale deed. Srimati Sureshwar, in the purchaser of Ram Sahai Singh, Ram Charitra Singh and Arun Kumar Singh, the son of Jagdish Singh. The defendant number 1, Ram Sahai Singh, is one of the purchasers of the suit property. He is the Benami holder, namely Ram Sahai Singh and Ram Charitra Singh and Arun Singh has been considered to be the owner of certainly Ram Sahai Singh has got 1/3 share of his property and he can net 1/3 undivided property to the other.
This is Ram Sahai Singh is the defendant number 1. इसका कोई अपील नहीं। This has become final. Have you stated so in your
जो I have said in para 7 अपील के बारे में नहीं वो नहीं
नहीं लिखे तो ऐसे अपने नॉलेज से कैसे बोलते हैं?
उसके अगेंस्ट में हम ही आए हैं केवल और कोई नहीं आया है मतलब हम तो अपीलेंट हैं पार्ट ऑफ द इसे देयर आर टू कनेक्टेड अपील्स फर्स्ट विथ रिस्पेक्ट टू द with respect to those points on which the appellate court has dismissed my appeal and the second is against that part of the first appellate court in which the respondent's claim has been accepted.
What is your terms of your joint compromise?
Since he has already purchased I have given 3 lakh rupees in cash to him by transfer he has no objection. The other 3
Seven is the terms of compromise.
Yes, 7 is the terms of
इसमें कहाँ लिखे हैं दोनों अपील डिस्पोजल करने में?
appeal you filed this idea has been filed in 191 the first case. Thereafter I have the second page I have mentioned it second appeal number 259 of 2015.
If you say that in view of this compromise, you do not want to press the other appeal, बात खत्म हो जाएगी. The story will be over.
Brothers and
ब्रदर्स है तो एक ही बात है ना, क्योंकि उसमें तो आपने कोई अलग से फाइल नहीं किया और इसमें कुछ लिख भी नहीं है.
दोनों अपील तुम लोग एक तो दोनों अग्रीव थे पूरे ये कॉमन जजमेंट से तो एक अपील तो 191 ही फाइल हुआ और सेकंड अपील जो हम ही तो फाइल की सिंस देयर क्लेम हैज बीन एक्सेप्टेड 259.
किसका क्लेम है? उसके अपीलान कौन है?
अपीलान दोनों में हम ही हैं.
आप ही हैं. ठीक है.
Kindly have not faced
What was the occasion to file two appeal?
because in the first there was in some of the issues were decided in my favor. The other side has also filed certain issues were decided in their favor. Therefore he has filed an appeal. That is at page kindly.
अरे भाई ये दोनों अपील तो आपने फाइल किए ना, arising out of the same suit.
Common judgment.
Common judgment.
Common judgment. Common judgment that is at
Common judgment and the same suit.
arising of same suit.
Same suit.
Same suit.
Right. So why the second appeal?
Because there are kindly have that common judgment.
The appellate judgment?
Yes.
Yes, yes.
The first title appeal 44 of 2010 Ram Sahai Singh the respondent number 1 and others. And the second appeal that is title appeal number 46 of 10 this is the appellant. Yes.
Okay, both the parties were agreed by the partly decreed. Second appeal number 191 of 2013. with second appeal number 259 of 2015. इसमें substantial question of law तो अभी तक नहीं बना है.
नहीं.
The learned counsel for the appellant has submitted that the matter has remained pending before this court and no substantial question of law as such has been raised so far. He has submitted that the dispute is primarily amongst the family members and
Except for the respondent number 2, Your Lordship.
No.
Not the family.
respondent number 2 is defendant number 1.
Yes.
Respondent number 2 is defendant number 1.
Respondent number 2 is the purchaser.
Purchaser of the land. That the one family member has sold the
Sold
land.
the part of the
Land
property to
property to
respondent.
respondent number.
So you are respondent number
2.
2. Except for respondent number 2, who is the purchaser of a portion of the suit. We submit that so far as respondent number 2, namely Lakshman Sahu, the learned counsel for the appellant has submitted that the defendant number 1, namely
Ram Sahai.
Ram Sahai Singh.
Yes. After his death, no,
Yes.
there's
Defendant number 1, namely Ram Sahai Singh, is all his legal heirs and successors have no stakes in as much as they have already sold the property to defendant number 2. To the defendant number 2, who is respondent number 2 in the present case. दोनों में पार्टी पोजीशन सेम है.
Yes.
The learned counsel submits that the suit was partly decreed and both the parties were agreed, and by the impugned judgment both the appeals were disposed of, and consequently 2 appeals have been filed before this court by the plaintiff.
Yes.
By the plaintiff. He submits that a joint compromise petition has been filed in second appeal number 191 of 2013, which would in effect dispose of both the appeals. He submits that the respondent number 1, that the defendant number 1 or the legal successors have not been made party to this joint compromise petition, as they have no stakes anymore. The right now devolves upon defendant number 2, who is the respondent number 2 in the present case. The terms and conditions of joint compromise has been mentioned in paragraph number 7 of the interlocutory application. It has been, the aforesaid submissions made by the learned counsel for the appellant has not been disputed by the learned counsel appearing on behalf of defendant number 2 and respondent number 2 in the present, in both the cases. We are appearing in both the cases? Yes?
Yes. For
Yeah,
3 and
for
4 also.
3 and 4. The learned counsel for the respondent number 3 and 4 also does not dispute the aforesaid submissions. और 5 कौन है? जी का तो डेथ हो गया,
3 का डेथ होने के बाद नोट सब्स्टिट्यूट
सब्स्टिट्यूट, ठीक है। 5 कौन है? अरुण सिंह।
वो 3 का डेथ हो गई नोट, तो वो सब्स्टिट्यूट होके 3 and 4 हो गया एक्चुअल में नोट कंटेनिंग रेस्पोंडेंट नोट, और 3 का उनका ऑलरेडी जो सन्स थे दे आर।
अच्छा, रेस्पोंडेंट नंबर on behalf of Ramchandra Singh and Arun Singh, ऐसा लिखते हैं, ठीक है? Who were originally made respondent number 4 and 5 in the present case, and their father was respondent number 3. However, upon death of respondent number 3, they have been substituted. They being the legal heirs continued as sons of late Jagdish Singh, right?
Yes.
The council subjointly submitted that the appeal be disposed of in terms of the joint compromise filed in the present case. After hearing the learned counsel for the parties, these two appeals are disposed of in terms of the Order 23, Rule 3 में joint compromise है लिखा है. In terms of the joint compromise filed through IE number 9818 of 2025. Filed in second appeal number 191 of 2015. दोनों अपील इसी से डिस्कस हुई हैं. The IE number 9818 of 2025 यहाँ तो appellate court का DT बनेगा.
यहाँ
सेकेंड अपील का DT बनेगा. Shall form a part of it. That's it. आगे तो disposed of. एक limitation का क्या है?
259 में IE 7109.
In view of the aforesaid order, IE number
7109 2018.
7109 of delay का note कर देते हैं. Seeking convolution of delay of 603 days in filing second appeal number 259 of 2015 days. Also continue. इस पे तो किसी को objection नहीं है. With the consent of the council for the respondents.
Appearance है ये.
Give your appearance and all of you put your signature. इनसे सही जगह पर enrollment के साथ sign करेंगे. Both the records. Put your signature in both the records. SA number call करें.
Item 10, second appeal 190 of 2022.
The matter has been fully heard on earlier date. The judgment is reserved.
Orders item 11, second appeal 224 of 2018.
I am appearing on behalf of the respondent number 2. As for respondent number 1 and 3, both of them have deceased, for which I am providing with the Vanshawali, so that they may issue notice.
We file an appropriate petition and nobody notice will be issued. When did they expire?
Lordship, that is not in my knowledge.
Vanshawali diye hain to. From where did you get this Vanshawali?
It has been provided by the your leadership respondent number 2 itself.
Respondent number 2. He has not given you the date of death.
No, your lordship. It's just the Vanshawali and the names of the legal heirs.
SA number 224 of 2018. You are appealing for respondent number 2. You are appealing for respondent number 2?
Yes, your lordship.
And Vanshawali of किसका देना?
Both respondent number 1 and respondent number 3.
1.
And the preceding Vanshawali as well. Preceding Vanshawali, like the Vanshawali of both 3 respondents, they all the 3 are siblings. Before that also I am providing information.
Against respondent number 1 has already awaited. The learned counsel for the respondent number 2 has submitted that respondent number 1 and 3 have expired. And the details of legal heirs and successors has been provided to the learned counsel for the appellant during the course of the day. He submits that the information has been gathered from the respondent number 2, but the date of death of respondent number 1 and 3 is not known to the respondent number 2. The office note revealed that the requisites were not filed in terms of order dated 3rd of July 2025. However, since the respondent number 1 and 3 has expired, the requisites need not be filed. Counsel for the appellant seeks a deliberate. How much time do you need? Substitution फाइल करना होगा ना? बताइए कब तक करनी? Close this case on 15th of October. Kiska Vanshawali are there? How many people are there?
Your leadership, actually the annexure,
Entire
yeah,
पूरा गाँव है.
they have provided the whole. The annexure 1 and annexure 2 are the Vanshawali of respondent number 1 and 3.
One is Sadilal Jalan,
Kanhaiya Lal Jalan.
Kanhaiyalal Jalan,
Yeah.
or
And respondent number 3 is Kaushalya
Kaushalya
Kedia.
Kedia.
Yes, your
Address?
address was not printable, your leadership, so I'll provide it through WhatsApp to the petitioners. Them. I'll do it today itself.
However, the counsel for the appellant has submitted that the address of the proposed or address of the legal heirs and successors has not been mentioned in the family tree. Counsel for the respondent number 2 undertakes to provide the address of the concerned persons within a period of 1 week. आपको जो है ना अपना order 22 रूल 10A में why have you not filed it?
Your Ladyship, I'll take instructions for that.
कुछ एरर हो जाएगा. आप ऑर्डर 22 में रूल 10A में क्यों नहीं फाइल करते हैं? आपका चेम्बर का केस है. यह पद आप ही लॉन्च.
This one I for order 22.
Item 11 चल रहा है. अभी item 11
Sir.
Who says it?
Mr. Amritansh Vats.
Sorry,
Mr. Amritansh Vats.
he does not know. ठीक है, प्रोवाइड करिए. आपका मैटर
Service report awaited as per last week.
so service has now it has come.
It's called this on delivered copy has not been received. First noting.
Appeal has awaited
Against this one and four.
four.
Yes. 2 and 3 appear. 1 के लिए हम substituted service के no not check. They are called as substituted service. And in this case, what happened was we
In
have
compliance of court's order dated 3/3/25, affidavits that respondent number 1A has not been filed.
here we are saying that we are not aware the legal here of 1A.
You are not aware.
Reasoning what happened in this case? No? Earlier we have filed a substitution application that was allowed. Subsequently, in exclusion case, substitution of the different person was allowed in the exclusion case. Subsequently, we have filed a modification application for lordship, and your lordship had pleased to allow the notices upon the both the legal heir in IN number 4784 and 72848. दोनों की appearance पे and as per the reports, I just undelivered.
किस पर undelivered है? सब
The first just next previous page, previous page. First notice. First.
देखिए, ID number 4784 of 25 has been filed for modification of order dated 22/6/2023, passed by a coordinate bench. Office is directed to place this case before appropriate bench for